Okay, we're on Unit 4, Authorized Relationships, Duties and Disclosure, a summary of the chapter. This is usually one of the most trickiest chapters to actually try and perceive and understand for the whole course. So this is a good way to get a little bit of basic training on it before we attend class, or to refresh what we've learned. We're talking about the law of agency. Agency is when people delegate authority to another to act on their behalf, and an agency relationship is created. Comes from law, three types of law: common law or unwritten law, usually judge-made decrees, and case law. Statutory law, especially the law that we'll find in 475 and 455, and then administrative law, which are the rules and regulations of FREC. Agency relationship in general business dealings: the person who is authorized to act for the principal is called an agent. If the agent is doing a wide range of duties, then that person could be regarded as a general agent. For instance, I employ you to list my house, sell my house, find a tenant, and manage the property. Or if it's just one particular avenue of duty, like I want you to list my house and that is it, or I want you to find me a house to buy, then that would be regarded as a special agent. Fiduciary relationship is opposite to what we normally do when we deal with other people on the other side, that is arm's length. And in those cases, that is a buyer beware, for instance. With a fiduciary relationship, we work very closely with our principal, and that way we have a fiduciary relationship. The principal is the person who delegates authority to another. And in the real estate office, the sales associate is a general agent of the broker, because the broker authorizes the agent to do multiple activities. There's always a bit of confusion exists as to who is representing whom, and it isn't necessarily determined by who pays and receives a commission. Normally, a seller will pay the commission to the listing broker, and the listing broker would then share that commission to the selling broker, the person who brings the buyer. Just because the seller is paying that commission doesn't mean that that seller has control over the selling broker. And that's what we mean by that. But we have three types of relationships in real estate transactions in Florida. First one is non-representation. There's no brokerage relationship. We don't represent either side or you. This might be, for example, a for sale by owner comes to us and wants us just to write a contract for the person, but doesn't want us to negotiate or do any dealings with the other side. Then we have a single agency relationship. Single agent: I can only represent the buyer or a seller in a transaction. That means I cannot be talking to or representing the other side in the transaction, nor can my broker, nor can anybody working for my broker. So that basically excludes anybody in the office working in the same transaction. Then we have transaction broker, where I or anybody in my office can represent both the buyer and the seller in the same transaction. When we talk to a customer or clients about the relationship we want, it is usually the agent or the employing broker that determines what type of relationship we need. The simplest and the first one we deal with is no brokerage relationship, or non-representation. We do have basic duties there. Even though we're not representing the customer, we do have to have these basic duties in mind at all times. Account for all funds. That means that if we are receiving any earnest money, or we're receiving security deposits and so forth, then we do have to account for them in a legal manner. We have to disclose all known facts that affect value of the real estate. If we know something that may be wrong with the property and is not relatively easily seen, we do need to disclose that fact to whoever we're dealing with. And obviously we have to deal honestly and fairly. ADD. No brokerage relationship. Florida law prohibits a broker and its agents from creating a fiduciary relationship with both the buyer and the seller in residential sales, even if two different sales associates from the same brokerage represent the seller and the buyer. A dual agent, that is a broker who has represented as a fiduciary both the buyer and the seller in the same transaction as a single agent to both. We'll talk a little bit later about single agency. Fiduciary is a relationship of trust and confidence between a broker as agent and a principal. A little bit strange it sounds, I know. When a contract is written between the broker and the seller or the buyer, then that contract is between those people and the broker, not between you as the agent. Therefore, you are represented as a sub-agent to the broker, and any duties that the broker confirms and applies to the relationship, they will transfer over to you. And also, of course, if you have an assistant, they will apply to that assistant as well. We talk about a single agent relationship. This is a single agent, a broker who represents as fiduciary and the agent either a buyer or a seller, but not both in the same transaction. That person is called a principal, and we also call them a client. The party client with whom the licensee has entered into a single agent relationship is a principal. We call them clients, not customers. Here are the duties of the single agents. If we're representing someone as a single agent, we have to account for all funds, disclose all known facts, the effective value of property, and deal honestly and fairly. We also have to use skill, care, and diligence and present any offers, all offers and counter offers. We also have the duty of full confidentiality, full obedience, full loyalty, and full disclosure to that client and that client only. You call your buyers or sellers, when you're working as a single agent, your client or principal. The one that we most commonly come across, and which makes more sense to a lot of agents, and that is a transaction broker relationship. Florida law, it is presumed that all licensees are operating as transaction brokers unless a single agent or no brokerage relationship has been previously established. And licensees don't have to are not required to give notice, written notice of this relationship. That was since 2008. We call folks that we work under transaction brokerage relationship our customers. Transaction brokerage relationship provides limited representation to a customer, not a client, because that would mean we represent him as a single agent, either the buyer or the seller or both. Does not represent either buyer or seller as a fiduciary or as a single agent, and the customer is not responsible for the actions of a transaction broker. In other words, the transaction broker is not under the duty of obedience, and therefore doesn't have to do everything that the customer asks him to do. If that was single agent, then they would be responsible for carrying out any legal requests from the single agent principal. We have slightly less duties for transaction broker. We have to account for all funds, disclose all known material facts that affect value, and deal honestly and fairly. Those three are with all of the relationships. We have to use skill, care, and diligence, and we have to present all offers and counter offers in a timely fashion. But instead of total confidentiality, we have limited. We exercise limited confidentiality unless waived in writing. We talk about that later in the chapter. And perform additional duties mutually agreed to. When you're working as a transaction broker, the parties do give up the rights to undivided loyalty. So the buyer and the seller must understand that we're sitting on the fence, not representing fully either one of them, but only limited actions and duties to both. Limited representation allows the licensee to assist both the buyer and the seller. They cannot represent one party to the detriment of the other when transaction broker for both, and you owe duties even though the disclosure is not required. There's a lot going on in this chapter, and I apologize for that. If for some reason, which we'll explain later, we need to transition a principal who has been represented as a single agent down to a relationship of transaction broker, so we can work both sides, then we do have a form for that. And Florida Statute 475 permits us to change that relationship by getting the principal to sign a consent to transition to transaction broker notice. In the case where both the buyer and the seller are represented as single agent, then both must sign the form. We just covered briefly about the timing of these disclosures. Non-representation, when a no brokerage relationship notice is being used, we must disclose in writing before showing a property, and a single agent disclosure before or at the time of entering into either a listing agreement or an agreement for representation for a buyer, or before showing a property, whichever occurs first. Transaction broker, the law says we don't have to disclose our duties and our relationship. And these duties are required in all real estate transactions, both residential and non-residential. The brokerage relationship limitations. If a brokerage firm is a transaction for seller, then how can we represent the buyer? And this is the tricky one. We can represent the buyer as a transaction broker or as a no brokerage relationship. If the brokerage firm is a single agent for the seller, then how can we represent the buyer? We can only represent the buyer as a no brokerage relationship with the buyer because two single agents aren't allowed to work together on the same transaction. Alright, so written disclosure is required in residential sales. That means we do have to provide them with a piece of paper that tells them exactly what our duties are. And we have to define what a residential sale is. Sale of improved residential property of 4 or fewer units. This means a single family home or a duplex, triplex or a fourplex. If the property is unimproved residential property intended or zoned for 4 or fewer units, we have to give them this piece of paper. And if it's agricultural property of 10 acres or less, we have to give them this piece of paper. The requirement to disclose does not apply to non-residential transactions, leases, auctions, appraisals, and any business opportunities. Take a note that these pieces of paper that we give to customers and clients being represented as no brokerage and single agent, they have to be given, and it's all about disclosure of the duties, but they do not have to be signed to be effective. The law is only about disclosing the duties in writing. Duties must be described and disclosed in writing for single agent or no brokerage. Can be included in the listing agreement, the signature line inserted following the disclosure. Single agent disclosure before or at the time of entering into a listing agreement or before showing a property, and a no brokerage notice before showing the property. Let's have a quick look here. Got Madonna and Elton John. They both want to be represented as a single agent. Can we work together in the same office under the same broker? Well, the answer is no. Red line means no. How about if Elton John was a transaction broker? Can we work in the same office with Madonna's home being represented as a single agency? No, and vice versa. What we can do, we can represent as a no brokerage Elton John. If he came in as a buyer as a no brokerage, that will work, or vice versa. Obviously, a transaction broker can work with a transaction broker, and a no brokerage can work with a no brokerage, and transaction to no brokerage, and transaction broker to no brokerage. It's still unclear, I'm sure. I will discuss this further in class, or this is just a recap of something you already know. As with any written document that has got a signature on it, or not a signature, but to do with a transaction, it has to be maintained, it has to be stored for 5 years by the broker. Brokers must retain agreements that engage their services for 5 years, and 2 years if there's a court case. And this also includes transactions that result in a written contract, includes files of properties that fail to close. There are exceptions. when do we have to not give these disclosure requirements? Well, we know when the other side, the other agent, is representing the buyer or the seller, either as a single agent or a transaction broker. If anybody comes into our open house or model home, if someone just taps us on the shoulder in the supermarket and starts asking us questions, or if I'm just responding to general questions of advertised property and communications concerning services offered, and when selling new residential units built by the owner, like an owner developer, I do not need to worry about providing these disclosures. We do have an exception for non-residential transactions, and that is when maybe two commercial customers want to use the same brokerage and they are prevented normally because of the no dual agency. Well, we do allow dual agency in these circumstances, and we call this designated sales associates. At the request of the buyer and the seller, the broker may designate designated sales associates to act as a single agent for both customers, different customers at the same transaction. But the buyer and the seller must sign a piece of paper stating they have assets of at least $1 million, and they do have to sign a designated sales associate form which outlines the duties of both agents. In that case, the broker just advises either agent and sits on the fence and doesn't get involved in the transaction. There are various ways a brokerage relationship can be terminated. The first one is when the transaction has been completed and both parties have achieved what their ultimate aim was, to sell a house and to buy a house, or there's a mutual agreement to terminate, or the agreement has expired, like a listing agreement has to have a fixed termination date, or the broker decides to terminate the relationship between a buyer or a seller and him, or the principal revokes relationship by giving notice. If the broker dies or the principal dies, if the property is destroyed or taken by eminent domain, or there's a bankruptcy of the principal or customer. So that is the end of Unit 4. A little bit complicated, and you probably have to go through it quite a few more times to get the gist of it. Go on and try some of the questions if you haven't done so already. Thanks very much.